Hi, everyone. We're so glad that we have such a large group live with us today. I'm Rachel Smith, and I am accompanied by Isaac Slutsky here. I'm a shareholder at Brooks Cushman, and I've been prosecuting patents in electrical and mechanical computer arts for well over a decade. Most of my practice relates to consumer electronics. I'm also part of our copyright and open source teams here at Brooks Cushman.
Hi, this is Isaac Slutsky. Thank you all for tuning in. I'm also a shareholder at Brooks Cushman, and my practice centers around mostly the preparation and prosecution of patent applications for computer-related inventions. Before I became a patent attorney, I was a computer programmer at what at the time was one of the largest software companies in Metro Detroit. So I've been working on different aspects of software for almost 20 years now. You maybe can't tell that from my bio picture, which probably needs to be updated.
So for the next hour or so, we will be discussing the 2019 revised patent subject matter eligibility guidance that was published January 7th of this month. We want to make this more of a conversation, so please let us know if you have questions or thoughts as we go through our presentation. Depending on the question, we may hold it to the end and try to address it then, but please don't hold back. So this guidance is a revision of the previous United States Patent Office procedures. The guidance indicates that it is applicable to all applications and to all patents resulting, filed before, on, or after the guidance. So essentially, as far as I can tell, this guidance is applicable to everything. The public is also invited to comment on the guidance. The deadline to do so is March 8, 2018. Comments may be addressed to eligibility2019@uspto.gov. In general, the guidance is intended to make examination under Section 101 more clear, consistent, and predictable, mostly for applicants.
And the guidance also comes with some additional examples of claims that do and do not meet the requirements for subject matter eligibility. As we go over the changes from the guidance, we'll discuss these examples, which we think are really helpful in showing how the new examination strategy is supposed to work. There's also some other materials that were released. There's some new form paragraphs for rejections made by examiners and a sample rejection for one of the example claims. And then there's also an FAQ of various questions for, they're useful for reading. Because these all offer, some additional clues on how we expect the PTO is going to operate moving forward. So the new guidance includes two main parts. First, we have some changes to the PTO's organization of the categories of abstract ideas. We will get this out of the way first. And then after that, and more importantly, the new guidance adds an additional step and a few other changes to the 101 analysis. Because there's only two steps to the Alice-Mayo test, this new step has to be called a prong of one of the existing steps, and we'll try to smooth that out a bit. But, despite the new guidance, the Patent Office states that any claim that was considered eligible before should still be considered eligible now. And this also implies that, more claims will be considered eligible due to the increased consistency, or else, why would the Patent Office want to make such changes? So, this is about as clear a statement as we get that the PTO expects this guidance to change the results that examiners are expected to get to, not merely change the approach that the examiners use. So, just to get the groupings out of the way, these aren't too much different than what we were dealing with before. The grouping of abstract ideas of mathematical concepts is about the same, and then the certain methods of organizing human activity group is also an existing group, but now it kind of swallows up the fundamental economic practices category, which used to be more separate. And, this makes sense logically because economic activity is a human activity. And, the FAQ materials also clarify that certain methods of organizing human activity could include a single person working with a computer, in addition to cases that involve an interaction between multiple people. It doesn't have to be an interpersonal relation to be in this category. And then the idea of itself category that we were used to seeing is gone, but we have a mental processes category. And it's, it's nice to not have to deal with the philosophy of what is an idea of itself. But, as we'll see in more detail, that a mental process seems to be a process that is a practical matter, can be performed in the human mind. And then, finally, there's also this asterisk, this tentative abstract ideas category, where an examiner can get the Patent Office to sign off on something that isn't an existing abstract idea. But, hopefully this doesn't happen. I mean, the guidance says it will be rare, but we would prefer this wouldn't happen at all because, the Patent Office is an administrative agency and really shouldn't be coming up with judicial exceptions. So using these categories, examiners will identify abstract ideas pretty much as they've done in the past. And now we'll move on to the remainder of the 101 part.
So we just want to look at the test and see what has changed. This is a snapshot of what the test used to look like. As many of us know, we have step one is the claim directed to a process, machine, manufacturer, composition of matter. And then we move on to step 2A and 2B. I believe most of us are familiar with this, but in the next slide, we're going to show you the new flow chart provided by the Patent Office. So here you can see this chart was actually provided by the Patent Office in one of their webinars directed to quality review. The Patent Office has essentially expanded step 2A, and as Isaac mentioned, by adding prongs. So we have prong 1 and prong 2. We'll be discussing these in more detail, of course, but essentially prong 1 corresponds to previous step 2A and asks whether the claim recites an abstract idea, law of nature, or national phenomenon. If the answer to prong 1 is in the affirmative, or the old step 2A, then we move on to prong 2. New prong 2 asks whether the claim recites additional elements that integrate the judicial exception into a practical application. That is, even if the claim includes the judicial exception, is the judicial exception included for a practical application? We'll discuss exactly what a practical application here is in a minute. But as an overview, we wanted to show you the test. So if the answer to prong 2 is a yes, then the claim is considered to be directed to patent-eligible subject matter, and the test is complete. This is probably the biggest change that the guidance gave us. If the answer to prong 2 is a no, then we move on to the traditional step 2B. And as you recall, in this step, we have to determine if the claim includes an inventive concept or significantly more. I also just want to point out that the cursor in the middle of the new step 2A was actually included in the Patent Office's materials as well, so I let it stay. So we thought the Patent Office's flowchart was a bit wordy, and just for our conversation today, wanted to simplify things a little bit. We kept the USPTO's nomenclature with step 1, step 2A, prong 1, prong 2, and step 2B. But essentially, these are 4 steps that you need to maneuver through when applying the patent eligibility test. Here, just to reiterate a little bit, we ask if we have a statutory category. For the most part, we assume that the answer to this question is yes, and through all the Patent Office's examples, the answer was always yes. If no, the test is complete and the claim is not eligible. If yes, then we move on to prong 1 of step 2A and ask whether we have a judicial exception. If yes to that, then we move on to prong 2 of step 2A. If no, we conclude that the patent is eligible. So at prong 2, we have whether judicial exception is included in a practical application. If yes, then the claim is patent eligible, and if not, we proceed to the old step 2B. In the traditional step 2B, the question of whether the claim is inventive is again raised. We're going to discuss the overlap between steps 2B and the new prong 2. Notably, this procedure appears to remain the same in that we first identify whether there are any additional elements in the claim beyond the judicial exception, and then evaluate those additional elements individually and in combination to determine whether they amount to significantly more. And we're going to apply this and show you via the examples coming in the next slide.
So just to move through the examination changes under prong 1, this is the wording on the guidance, from the guidance about how examiners are supposed to do this. So in prong 1, examiners evaluate whether the claim recites a judicial exception. To determine whether a claim recites an abstract idea in prong 1, examiners are now to identify the limitations that recite, using those revised categories of abstract ideas just to see if there's a match. So this step is basically the same as before, except now examiners are to use the new groupings. And actually in the Patent Office FAQ, one of the questions that's asked is, can I still rely on the quick reference sheets identifying abstract ideas that the Patent Office had been putting out? The Patent Office is clear that the answer is no, that this new guidance supersedes all versions of the abstract ideas quick reference sheet, and it's no longer to be relied upon by examiners. So this is the examination changes in the new prong 2, where things are more different. Now, examiners are to evaluate whether the claims recite additional elements that integrate the exception into a practical application of that exception. So, well, how do examiners go about doing that? Well, the guidance generally says that, they'll check to see if the judicial exception is used in a manner that imposes a meaningful limit on the judicial exception more than a drafting effort to monopolize the whole idea. And unfortunately, that's really more of a conclusion and not a way to figure out what the answer is. Moving on, there is more guidance than that. First, the examiners look for additional elements kind of similar to how the analysis might have been under step 2B. And then the examiner evaluates those elements to see if they integrate the exception into a practical application. And notably, and we'll touch on this again, unlike the determination of significantly more at step 2B, there's no consideration of whether those additional elements are well understood, routine. Turning to slide 12, the guidance does provide some explanation of what additional elements may be used to show a practical application. And these include some of our old friends that we've been dealing with before, like improving the functionality of a computer or an improvement to other technology or to another technical field, whether you're applying or using a digital exception to affect a particular treatment, kind of a claim that's not a pure software example, but generally this list of things, affecting a transformation or you're something else, these are pretty much similar to the examples that we were using before. And notably, this is still not an exhaustive list, and there could be other reasons as well. And finally, let's look at the changes in step 2B. So, as before, in step 2B, examiners determine whether the claim recites additional elements that provide an inventive concept that's significantly more. And, a lot of this analysis of additional elements is also done now for step 2A. So the guidance notes that many considerations in step 2A need not be reevaluated in step 2B. Examiners should continue to consider in step 2B whether the additional elements represent well understood routine conventional activity, however. And this aligns with the statement earlier that under 2A, examiners should not consider those factors. And just as a final note, noted in the Patent Office FAQ, examiners still have to provide proof to support an assertion that an element or a combination of elements is well understood routine or conventional activity in accordance with the guidance following the Berkheimer decision.
So it appears that the threshold for prong 2 of step 2A is actually lower than that traditionally in step 2B. But would you ever have a case where the claim fails step 2A, prong 2, but could pass step 2B?
So I guess your question is, in what situations would a claim fail to integrate a practical application but still recite significantly more? And the guidance notes that a step could be insignificant extra solution activity in the revised step 2A, but it could also be done in an unconventional way to pass step 2B. And the FAQ is also consistent with this and says that, note, the other considerations besides insignificant extra solution activity may not need to be reevaluated in step 2B because the answer will be the same. However, it appears for now that cases that fail step 2A but that pass step 2B will be rare. And in fact, none of the new Patent Office claim examples are resolved in this manner.
Okay. Well, speaking of examples, I guess we will get to them here. We selected a few of the examples that the Patent Office provided to go over to show the operation of the test. The Patent Office cautions in the FAQ that these examples should only be used for that. That is, the example should not be used for a comparison of subject matter to show a claim is eligible. For that, you should compare the claim concept in your application to the enumerated groupings that we talked about earlier. Also, the FAQ notes that we should only rely on the new examples to help understand how to apply the 2019 guidance. The office goes so far to say that you should rely on the new examples 37 through 42 to help you understand how the office applies the 2019 PG in certain fact-specific situations. The existing examples 1 through 36 were issued prior to the 2009 guidance, and some of them present analysis that may be entirely consistent with the 2019 guidance. Thus, although the claims indicated as eligible in prior examples, they are still eligible today. So essentially, I guess, and maybe Isaac, you can opine on this, but if you have a canned 101 arguments that you've been using, because since we've been dealing with these types of rejections over the past few years that reference prior examples, you may want to reevaluate whether those are still relevant.
Yeah, and theoretically, we probably shouldn't be arguing the subject matter in the examples because the Patent Office has really taken the position that the examples are just to explain the mechanism of how the rejections are done, not that these are good and bad subject matter examples necessarily. But that said, a lot of the existing examples, especially the ones that were based on prior case law, it seems difficult for the Patent Office to walk back from those and say that that analysis is no longer consistent with these new proposed guidelines.
Sounds good. So as we go through these examples, we will be stepping through the 4 steps that we described earlier. We'll be assuming that step 1 for the test has been met and that the claim is directed to a process, machine, manufacturer, composition, and matter. Notably, each of the claims presented by the USPTO are directed to methods. So we're going to start with example 37, claim 3. Example 37 is directed to a user interface having multiple icons. The invention arranges the icons so that the icons that are most frequently used are positioned closer to the start icon. The amount of use in this case is based on the number of times an icon is either selected or by how much memory has been allocated to the processes associated with the icon. We have claim 3 up on the screen, and as shown, it determines the amount of use of each icon and subsequently ranks the icons based on that amount of use. So we're going to go ahead and apply our 4-step test, assuming step 1 is satisfied. We're going to look to step 2A first. We ask the question, is this directed to judicial exception? The answer here is yes. That is, other than reciting by a processor, nothing in the claim element precludes the step from practically being performed in the mind. We have determining by a processor the amount of use of each icon over a predetermined period of time and ranking the icons by a processor based on the determined amount of use. The fact that a processor is generally referenced does not pull these steps out of the manually performed category. Because prong 1 is directed to a judicial exception, we're going to move on to prong 2. And here we ask, is the judicial exception integrated into a practical application? So here, USPTO's examples with respect to prong 2 gives a bit of an idea of what is a practical application. In this example, the Patent Office says that both steps in this claim are recited at a high level of generality and do not integrate the abstract idea into a practical application because it does not impose any meaningful limits on the practicing of that abstract idea. Essentially, we think that the takeaway here is that simply ranking icons based on use is not enough of a practical application to satisfy the new prong 2. Because we fail prong 2, we move on to the old step 2B as a last-ditch effort to be patent eligible. And here we revert to the traditional test that asks, is there any inventive concept or significantly more? The answer here, which is not surprising, at least not to me, is no. These are merely instructions and do not involve an inventive step.
So just to summarize this a little bit, just ranking the icons but not doing anything with that ranking doesn't involve either a practical application or significantly.
Correct. And that's according to the Patent Office, and I think we agree with that too. So moving on to our next example, in contrast, let us look at claim 1 of example 37. This claim includes additional recitations such as determining the use over a predefined amount of time and automatically moving the icons. In contrast with the last claim, we have automatically moving in lieu of the ranking step, which apparently wasn't enough. So in this example, prong 1 has the same outcome. Nothing precludes these steps, per se, from being done manually. I could click and move an icon, hypothetically I could click and move an icon or rearrange it on my computer desktop. So we move on to prong 2 once we establish that this does include judicial exception. We ask, is this integrated into a practical application? The Patent Office said yes. The Patent Office says the claim as a whole integrates mental processes into the practical application of automatically displaying icons based on usage, which provides for an improved user interface for electronic devices. Thus, it would appear that simply ranking the icons is not enough to satisfy the practical application prong, but automatically moving such icons is.
So it seems that in this example, it's that performance of an additional action, the automatically moving, is enough to satisfy the requirement. And it's also, while it's not really that much, and while moving icons itself isn't new, this additional action is a practical application of the general idea of ranking things.
So we're still going to look at example step 37, so we're still dealing with icons and user interfaces here. Claim 2 of this example includes tracking the amount of memory used by each application associated with the respective icons. Claim 2 also includes, similar to our most recent example, the automatically moving language. We can unlikely assume, based on the previous example, that this claim is patent eligible. What is interesting about this example is that the Patent Office indicates that the claim is not directed to an abstract idea. So we are on prong 1 right now, and the Patent Office says that determining memory usage cannot practically be performed in the human mind because it actually requires the processor to carry out this action. I kind of like this example, not because of the outcome, but it tells us that while we're focused mostly on trying to discern what a practical application is in view of this new guidance, it kind of reminds us to still go back to the fundamental idea of what an abstract idea actually is and focus on those definitions and the judicial exceptions. It also, when evaluating these, helps us to remember that we need to address the abstract idea and not just prong 2.
But it also seems that when, drafting claims, if we are clear that we have a step that cannot really be performed in the human mind, for example, requiring a data element that a computer would use to make a determination, but maybe a human being would not use, might be a straightforward way to avoid a claim being directed to an abstract idea.
Mm-hmm. Okay, so we are finally moving away from computer icons. Example 38 is directed to simulating an audio mixer to create a more authentic sound for the user. The invention takes into consideration the location of various circuits, manufacturing tolerances, among other values. Claim 38 recites manufacturing ranges and then simulating a digital representation based on the model and the values. So what do we think on this one? Again, similar to the last example, we look to prong 1, or the original step 2A, and evaluate whether this is directed to an abstract idea. The United States Patent Office says no. The claim does not recite a mathematical relationship, formula, or calculation. The claim does not recite a mental process because the steps are not practically performed in the human mind. This makes me think back to the ranking of icon examples.
And kind of, again, we seem to be focusing in these examples a lot on what can or cannot be done in one's mind. And part of that's because the examples you've looked at so far are not fundamental economic practices or interpersonal relationships. But looking at this claim, I think that it's the simulating step that shows the practical application more clearly. It's probably not whether the generating step would have been enough. And I think about this because I had a case that was pretty similar to this example where, the claims involve stress relief in a finite element simulation, and the examiner had said that the claims, they just amount to math from his perspective, and math could be done by a human being, regardless of whether doing so would be practical. And today, it seems it would be much easier to get over a 101 rejection of that claim if you were even to receive one. I mean, it would even be fair to say that in view of this guidance, the PTO thinks that the rejection we received for that case was probably unfounded.
So we'd like to discuss just one more example here today. Just notably, you can read about all these examples that we're going through today, and then some of the other ones as well that we haven't covered in the PTO guidance. It's a link on the Patent Office there with it. So in this slide, in example 42, we have claims directed to a method, user interface, where a user receives an update about a patient's medical record. The update may be entered in any format, but converted to a standardized format for delivery of the update. Claim 1, as you can see, recites the converting the non-standard and the standard formats and transmitting the messages to all of the users. So do we have a judicial exception? Yes. The claim as a whole organizes human activity. This is because the claim talks about patient and user interaction using a network system. Again, it seems to be a fine line between human activity and not. In the previous example, the simulating would not be considered human activity. However, I would possibly argue here that converting medical formats to be stored and transmitted would not be considered human activity as well. I would argue that the claim does not recite a mental process because the steps are not practically performed in the human mind. However, the Patent Office did indicate that this is an abstract idea, and thus we are going to move on to prong 2, at least for this example. So, does this have a practical application? And the answer is yes. Allowing remote users to share information in real time in a standardized format is a practical application. Thus, the claim is patent eligible. Now, it lends me to believe that alerting is not enough. I think what pulled this into the practical application is the fact that we took it from a non-standard format at the input end, and at the output end, converted everything into a standardized format to alert the user. So we're going to look at just one more claim here. Looking at Claim 2 in the same invention stores information and provides access to the information. Claim 2 stores the updated information, but not necessarily in response to the accessing or another event. So you can see where we're going here with this one. Since Claim 1 is directed to an abstract idea, so is this claim. The example is more clear to me with respect to the abstract idea, at least because we are simply storing and processing data. There's none of the conversion of formats, or alerting, anything like that. With respect to prong 2, however, The steps are recited in a very general manner, and simply storing and updating information is not enough to be considered a practical application. So it appears that in order to be a practical application, some result or some form of action must be taken place in response to another step. We can't just simply go through storing and sorting data. So even though we failed prong 2, we have one more chance to get the claim through if we can be eligible under step 2B. The Patent Office indicated that simply storing and updating data does not include an inventive step, does not include significantly more, and therefore we have a patent eligible subject matter for this example. So interestingly, the office did not provide any examples where prong 2 failed, but step 2B did not, as we've kind of mentioned before.
Yeah, there's no explicit examples other than some quick mention in the guidance document.
Correct.
So on this slide, we're trying to kind of summarize some of these arguments that we think might make sense to make based on the new examples. So at prong 1 of step 2A, there's a few things that we might be able to say to argue against the claim being considered to be an abstract idea. If there are, some ideas in the claim of things that could not be done mentally, like, access to computer-specific data, then that might be enough. We could also argue, that the steps could not be performed in one's mind as a practical matter. And for, step 2A, prong 2, we would want to focus on the additional elements that we discussed before. Does the claim accomplish something with the actions that are performed? Does the claimed invention improve the computer or maybe some other technology? And so on. This analysis should be pretty familiar based on how we would handle step 2B previously. And then finally, for step 2B, most of what we might have said before would now be, maybe argued for prong 2. However, here, we would want to additionally focus on whether there are some additional elements that are not well understood, routine, or conventional, and, and if the Patent Office had made any statement here to make sure that what they said was backed up with evidence. So basically, that's how we see the new framework. Some final thoughts on our prepared slides. As we kind of discussed at the beginning, the Patent Office is doing this to improve clarity and consistency of examination. And, for the past several years, 101 has kind of become the gatekeeper for so-called bad patents, where patents that are overbroad or that don't really describe anything, or, patents just seem ridiculously obvious. The category of patents that might embarrass the Patent Office later. So in view of this guidance, the office seems to be scaling back their efforts on limiting such patents under 101. However, at the same time, the Patent Office also released some new guidance under 112 at the same time. There isn't really new examination guidelines for the 112 guidance, but that's, really seems to be because the 112 guidance is more a summary of existing procedures. We can expect that moving forward, though, the PTO is probably going to push for more rigorous examination under 112 as a mechanism for ensuring patent quality. As far as ongoing prosecution, there were a couple things that we were thinking about. One of them from the FAQ about the scope of the revised categories of abstract ideas. But the Patent Office says that these definitions are not intended to sweep in more types of claims than under the prior guidance since 2014. And any claims that are considered eligible under the current version should still be considered eligible. So it's pretty much all these changes are erring on the side of more claims being eligible, not fewer. And then also looking through the FAQ, there's a lot of material about how to address cases that are currently being prosecuted. The Patent Office takes the position that a rejection under 101 is still basically the same thing, even if, the examiner is relying on the new charts of abstract ideas as opposed to like prior charts or like case law directly. If still the general thrust of it is the same, there's no need for example, a new non-final. And also if you're under appeal, there's still discretion on whether the Patent Office needs to reopen prosecution or maybe if there's still time, issue a new ground of rejection in the examiner's answer.
So essentially, if we're mid-prosecution and we've already overcame a 101 rejection on similar claims, we shouldn't expect any new 101 rejections under the new guidance.
I mean, assuming the Patent Office, holds the line on this guidance not making anything ineligible that was previously, we should really expect not to. And as we mentioned before, the new tentative abstract ideas category seems a little bit unusual because, the Patent Office really shouldn't be providing new judicial exceptions. And beyond that, as far as the effect on litigation, it's not, it's not clear how PTO guidance will affect courts. It's also not really clear how these new guidelines will affect, CDM or PGR procedures that are ongoing. It seems it's possible that in some cases where there were one-on-one issues, that there might be additional briefing that be required.
So I think that pretty much concludes our formal portion of our presentation. If anyone has questions, they can feel free to type them in and we can address them at this time. So for future, I believe this webinar is going to be available on our resources page of the Brooks Kushman website, probably by early next week. And Isaac and I are happy to have a separate discussion or answer any additional questions with each of you. I think we have a question. We've allowed that person with the question to talk through the webinar.
Oh, hello.
Hello, is this Mark?
Yes, it is. Yes, it is.
Okay, question?
Well done presentation. It's very good.
Thank you.
When I look at what the PTO did, I've been writing patent applications for 30 years. I don't see a major change here. What did I miss? What do you see as a new anything here?
Well, I'll let Isaac answer, but in general for me, it's that they're trying to increase the quality, but without using 101 to do so. I think they don't want the patent eligibility to get in the way of the quality. They want the patent eligibility just to deal with the allowed subject matter.
I think from my perspective, one of the issues sometimes when you're arguing a 101 rejection and the examiner's being stubborn is you don't always have anything good to rely on to kind of bring the examiner back to earth. So, I think that the new guidance gives us some additional things that we can say that would have, because examiners like things that are in the MPEP, so it gives us authority from their rule book to explain, using the patent office's own words, why a rejection might be incorrect.
Yes, I see. Oh, very good. Thank you very much.
Thank you. I don't see any other questions. Please feel free to reach out to us if there are. And we appreciate everyone's time and hope you found it helpful in navigating the new guidance.
Thank you all for coming.